freedom of speech,
fundamental rights,
freedom of conscience,
academic freedom,
freedom of press,
and the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights in Education.
Okay, welcome back to So to Speak, the free speech podcast, where every other week we take an uncensored look at the world of free expression through personal stories and candid conversations. As always, I am your host, Nico Perino, and today I'm joined by two of my colleagues here at FIRE, Robert Shibley and Samantha Harris, two colleagues that you all are well familiar with because they've appeared on the podcast many times at this point. Robert is, of course, the executive director at FIRE. He's my boss. And Samantha is a senior fellow at FIRE, and she is also an attorney at Mudrick Zucker, where she represents students and faculty members in disciplinary hearings. Robert and Sam, welcome back onto the show.
Thanks for having me.
Thanks for having us.
So today I kind of want to just do a roundup of what's been a crazy summer at FIRE. I mean, 2020 has been quite the year in all regards. But at FIRE, we led off the summer in May with the finalization of the Title IX regulations. And tomorrow, actually, we're recording this podcast. It's 10:45 a.m. On Thursday, August 13th. Tomorrow, August 14th, is the day we have kind of all been waiting for, the day that these new Title IX protections for free speech and due process go into effect. Now, there are a lot of legal wranglings about these regulations, and you never know what shenanigans might happen between the time we record this podcast and when they're set to go into effect tomorrow. But Robert, do you want to give us an update as to what's been happening over the summer?
Yeah.
And where things stand now?
Yeah, absolutely. So the opponents of the new regulations, which both put in a Supreme Court approved standard for sexual harassment, which is protective of free speech. That's what we call the Davis standard, if you hear us talking about that. And also a number of really important protections for people who are accused of violating Title IX policies. These protections include things like an explicit presumption of innocence, or being able to face your accuser and cross-examine, really basic things like that. And
things that colleges and universities, for the most part, hadn't been promising those accused on campus for years.
That's right. As I love to remind people, more than 70% of the top 50 U.S. news schools didn't even explicitly say you were innocent until proven guilty if you were accused, which is really, square one of trying to put together a justice system is really innocent until proven guilty, and they didn't even bother doing that. So that's a good indicator of the contempt with which schools tend to show or tend to view these protections.
And before we continue, we should just kind of quickly define Title IX. It's a law passed in the 70s that essentially says that people need to be treated fairly based on their sex.
It bans sex discrimination in federally funded education programs, which includes, because of student loans and because of aid to K through 12 schools, it includes pretty much every public K through 12 school, and then every public and virtually every private college or university.
Yeah, and sex discrimination is held to also constitute sexual harassment.
That's right, sexual harassment, and it also now covers, because of a recent Supreme Court case, sexual orientation, gender identity.
Mm-hmm. So with those caveats out of the way.
So there have been the opponents of this speech protective standard and these due process regulations and guarantees have filed four federal lawsuits in four different districts, one in Maryland, one in the District of Columbia, one in the Southern District of New York, which is New York City, and one in the District of Massachusetts. And this week, because the regulations go into effect, 3 out of 4 of these cases had asked for a preliminary injunction that would prevent the regulations from going into effect tomorrow and on August 14th, which is the date. And this week, so far, we've seen 2 of those preliminary injunctions be denied. The one in New York by a federal judge appointed by President Clinton, and one in D.C., which was the quote unquote big one that involved 17 Democratic state attorneys general and the District of Columbia attorney general. And that was denied by a President Trump appointee. So we have sort of a bipartisan, shoot down of the idea that these regulations shouldn't be allowed to go into effect. So unless there's a ruling out of Massachusetts today, which is possible, but probably not that likely, tomorrow these protections will go into effect. And that means that university policies as of tomorrow need to integrate these protections for people accused of Title IX violations, or they are out of compliance with federal regulations. And ultimately, if they were to refuse to get into compliance, they could be stripped of their federal funding, which is the death sentence to most schools. Harvard or Yale might survive it, but because you would lose student loan funding, it really is a very harsh penalty. So harsh that that's never actually happened. So it's never happened in 30 some odd years. So the odds that any school would actually go that far are basically zero. But what it does mean is that schools do have to take these regulations seriously.
Yeah, and have they been doing that, Sam? Have you noticed that schools have started to change their policies? I mean, they have to have prepared for the policies to go into effect tomorrow. It's not like you just start implementing policies tomorrow.
Yes. I mean, schools are not yet applying these policies to their new cases, but, schools are, as far as I'm aware, and in terms of their way they communicate with students, in the process of revising their policies. There have also been, particularly with my practice here in Pennsylvania, there have been court decisions that have also required schools to update their policies. So, I think that we can expect to see a lot of changes coming in the fall. Now, it remains to be seen what those will look like, because Princeton, for example, has adopted one policy that complies with the new Title IX regulations, and that's for only those acts of misconduct that are defined, under the regs as violations of Title IX, and then a much more expansive list of acts of misconduct that the university wants to investigate on its own as sexual misconduct are covered by another policy. So that may be something that we need to look out for as schools try to find ways to get around, what they view as requirements they don't want to have to comply with, such as providing hearings and cross-examination.
Yeah, I actually saw that come across the news, and I'd been meaning to get in touch with you, Sam, to kind of discuss it, because I don't understand what that means. So does it mean that if a student is charged with sexual harassment, the only thing they need to do an end round around the protections that the new regs provide is to just not call it a Title IX violation?
Well, my understanding, and I don't have the policy up in front of me, so I don't want to speak beyond what I know. But one of the big complaints about the new regulations is that jurisdiction under Title IX is limited to conduct occurring within a school's education program or activity, and that includes student organization facilities, fraternity houses, and things like that are owned by the university. But it doesn't necessarily include off-campus conduct. And so one of the big complaints was that, a lot of sexual harassment and assault that may take place in off-campus housing and things like that wouldn't be covered. And so my understanding is that this policy creates a more expansive definition of prohibited conduct that includes that type of off-campus misconduct, and that it is covered by another policy.
It's the reason for that limitation and that people are complaining about is actually it's in the text of Title IX itself that was passed back in the early 1970s, says that it's in federally funded education programs. And so I think the very solid logic of this is that, well, if it's not in there, we don't actually have jurisdiction over that. So there are those complaints about it, but there's also the fact that a big part of the reason that schools, and Title IX doesn't expect them to have, the law itself doesn't expect them to have, policies to necessarily to address that, is that if it's off campus and has not under the control of the school, it's very unreasonable to expect the school to be able to do any kind of effective job in finding out what actually happened there. I mean, we've had instances of schools attempting to adjudicate sexual harassment that happened, while both parties were abroad in another country. and that sort of thing. It's just the ambit of, I don't know, I'm trying to think of a mid-tier state university, just doesn't have that much influence over the government of the Republic of France or something like that. So, I think it wisely recognizes some of the limitations of schools. I think one thing that the system that Princeton and maybe some other schools will try to turn to really does, the message that it really sends is that these unjust kangaroo courts are really, really important to schools. And I think it's inescapable that the reason for that is political. And it's about making a political statement rather than about students. We've seen too much of this, and we've had too much discussion of this over the last 10 years to pretend that, schools are on the up and up when it comes to these kind of protections. And Sam has all kinds of horror stories she can tell you, but I think the idea of putting faith in schools to adjudicate these really sensitive cases without the protections they've been denying for so long has repeatedly proven to be a terrible idea. That gives us basically an unjust system that is dependent on the political whims of those in power on campus. And the fact that schools are like Princeton are going out of their way to do that, I think shows some really serious, moral turpitude on their part. I mean, I have
Moral
strong
turpitude. Good line.
I have very strong feelings about this. They have not proven that they are going to make an effort to be fair about things. And now they are trying to, again, warp policies so that they can punish people for things that, are often protected speech, are often, very highly politicized ideas about consent, like affirmative consent and that sort of thing. And so, frankly, I think it's disgraceful that this is happening. And I would be happy to debate, the schools on their records on this, but I can guarantee you that none of them would agree to do it. And if I were them, I wouldn't agree either.
Well, one of the things that we've learned in the work that we've done with free speech on campus, of course, is that even when you are required by law, by, say, the First Amendment, to provide students with certain rights, colleges and universities will just ignore it and violate those rights anyway. And that's, why an organization like FIRE needs to exist. So while tomorrow, August 14th, is a big day for us, we've been fighting for this day since April of 2011. The fight won't be over, of course. We will still have to work to ensure that universities respect the law and that students and faculty members are accorded the rights that they're given under the law.
Really important thing is that what schools are missing here is accountability. Nothing bad ever happens to the people who make these unjust decisions and ruin people's lives. There is a total lack of accountability on the part of university administrators in this. Were I them, I would be fighting very hard as well. Well, I'd like to think I wouldn't be, but I can understand why you would fight to have a job where you have no accountability for making unjust or morally wrong decisions. But that doesn't mean that we have to accept it. And I think a really important part of these regulations is the beginning of accountability starting to finally come to people who, with very good reason, think that no matter what they do, they will never have to actually face any consequences for it, no matter how bad their decisions are, no matter what they do. I think this accountability is very, very important. And frankly, I think it's overdue. And I think universities have squandered a lot, maybe most of the goodwill that they've built up over the last few decades in terms of being trustworthy. And I think there's probably going to be more of this because I don't think people are willing to simply accede to whatever, a university president, dean, student life, et cetera, says anymore. And I think that's good. I don't think they should be acceding to it.
Well, on the topic of accountability, that just got me thinking. I mean, Sam, you work on the due process litigation database that we have here at FIRE, and which is a tremendous resource to seeing what the courts have been doing on these topics. Let's say a student successfully sues their university for a violation of their rights under Title IX or under principles of due process. how are the administrators who violated those rights held accountable, or does the doctrine of qualified immunity protect them along with the university's insurance policies?
Yeah, unfortunately, qualified immunity is a huge hurdle in these cases, as it is to justice in so many cases
And
involving
we should probably
malfeasance.
we should probably define qualified immunity for
Yeah,
some of our
sorry.
listeners
So,
who aren't.
qualified immunity is a judicially created doctrine under which, so there's a statute at Section 1983. It's a civil rights statute that allows people who have been harmed by state officials, whose constitutional rights have been violated by state officials acting under color of state law, to bring a federal lawsuit for damages against those state officials. Um, and the courts have created a doctrine known as qualified immunity, under which those officials can only be held personally liable, meaning they will individually have to pay, money out of their own pockets, if the constitutional right they violated is clearly established. And this has become an almost impossible hurdle to overcome. So, for example, there was a case in the 10th Circuit where a student who had posted, he was a medical student, and he posted an anti abortion post on Facebook that was completely constitutionally protected, but it was intemperate, right? And the school punished him for it. And it was a public school, a University of New Mexico, I believe. But the public school punished him for it, and he brought a First Amendment lawsuit. And now it is, to me, very clearly established that it violates the First Amendment to punish someone for the content of a Facebook post in which they are discussing their sincerely held beliefs on important political issues. Um, but the court granted the administrators qualified immunity, basically holding that because there was no clearly established precedent about the free speech rights of students in professional schools involving online off campus speech, that the right was not clearly established. And the problem, there's sort of a double problem, and I hope I'm not getting too far into the legal weeds here. But
No, I
another
think our listeners will find this interesting.
Another problem with the doctrine of qualified immunity is that courts are given a choice. Under Supreme Court precedent, they have the choice of whether to do the First Amendment analysis before the clearly established analysis. So they can do one of two things. They could hold that, yes, a right was violated, but no, the right wasn't clearly established. Or they can say, the right wasn't clearly established, so we don't actually need to answer the question of whether the right was violated. And more often than not, they choose the second. They do the clearly established analysis and they avoid answering the constitutional question, which creates this additional problem because how can anything ever be clearly established if constitutional precedent is not being made? So not only does qualified immunity serve as a barrier to holding these officials accountable, it also creates a system in which it's very difficult for rights to ever become clearly established.
If you're a cynical anarcho-libertarian who thinks that the government is just out to protect itself and the powerful, qualified immunity is pretty much, evidence, exhibit A in doing that because of the way that it is applied. It does end up being a get out of jail free card for so many people. And I'm not an expert on how this applies in the police context, but some of the decisions about the way that the police are allowed to treat suspects and that sort of thing will really curl your hair when you see how into the weeds courts will get about establishing what is clearly established and what is not. I mean, it really is. If you want to drill all the way down, every instance of everything is unique, and so ultimately, it really is. It really does end up turning into a sort of the judge's opinion on whether or not they think this person should get away on a personal level with this particular civil rights offense. And
Robert, I have curly hair, so I'm not sure how I feel about using the phrase "curl your hair" to
I
refer
have
to
no
a
hair.
negative consequence. But
I have no hair, so I have no sympathy for you. But go ahead.
Nico, I also wanted to sort of address your question beyond just the issue of qualified immunity because, a lot of these students who have been denied due process have brought lawsuits, and not just constitutional due process, because these are students at private universities often too, and they're bringing suits both for sort of reverse sex discrimination, but also breach of contract when schools don't follow their own policies. Um, so, uh, you know, these cases, there have been several decisions, including one that I alluded to earlier in the Third Circuit at the University of the Sciences in Philadelphia. There was one at the University of Michigan. There have been a few sort of seminal cases where courts have issued pretty sweeping precedent that has really, improved the rights of students across the board. But for the most part, these suits can be a way for an individual student to get justice. Very often there's a settlement. If the case gets far enough in litigation that it survives a motion to dismiss, very often the university will settle the case, which may lead to a positive result for an individual student, such as their record being cleared. But in terms of really holding these officials accountable for their malfeasance, the courts haven't really been able to do that. You don't see huge jury verdicts of the sort that would really be necessary to send a message to administrators, to universities. So, I do think the judicial remedy is very important. And it can be very useful, as I said, for individual students. But I think both in the due process and in the free speech context, which I know we want to also transition into, this lack of accountability, both financial and sort of moral accountability for what universities are doing to these students and faculty is really a huge and ongoing issue and one that needs to be addressed.
Well, I remember when I was at our co-founder Harvey Silverglade's house. What was that, earlier this year, last year? All the years are blending together at this point. We were talking about the 20th anniversary of FIRE, and he said one of the things that really helped get universities to be held accountable was to name names. So to the extent that there was an administrator who was violating a student or faculty member's rights, he said we would put that in our press release. We wanted to hold that person personally accountable for the violation of rights. And, a lot of people in higher ed, and most of us anyway, are care about our careers, and you don't want to come up in a Google search result as violating someone's rights. So that's one way in the court of public opinion that FIRE, since our founding in 1999, according to Harvey, has held folks accountable. But Sam, you mentioned wanted to transition into free speech as well. This has been a big summer generally for free speech. Not always in a good way, though. Title IX is going to give students certain free speech protections that we've long fought for. But the month of June, to put it in context for our listeners, summer is kind of usually a down period for FIRE, naturally so. School is out of session. So in 2013, we had 27 case submissions in June. 2017, we had 66, 2018, 38, 2019, 59. This June, we had 289 case submissions, 289 examples of students or faculty members coming to FIRE for help because they felt their rights were violated. The focus and interest and need for FIRE's help over this summer has also been reflected in just our website traffic. Our traffic in the month of July was higher than it's been at any other point in the past year and a half. And when you consider that summer and July in particular is usually our down month, it's quite extraordinary. So, Robert, you've been doing this for 20 years, 17 years, somewhere around there. Why was this summer different?
Well, I mean, the words cancel culture spring to mind. I know it's on everybody's lips right now, and there's a lot of disagreement about what it means, and whether or not it's a good thing, and what even counts as cancel culture. But the main driver of these cases coming in was students who were facing some sort of either inquisition, some inquiry, potentially actually being expelled or seeing their admissions rescinded from schools because of things they had said that were critical on social media of either George Floyd, of Black Lives Matter, of the protests and or riots and looting. And that was really the driver of those cases. And I think that's largely because, I think some people know this, but maybe not everybody does, is that there was actually sort of a coordinated, loosely coordinated effort, as far as I could tell, to actually dox people, during this time. And, if somebody were to say something critical, the way it would work is you would go back, look for, and you could see this in some Twitter timelines. Like, it's sort of interesting to see. I mean, interesting in sort of a terrifying way of how this works, sort of crowdsourcing research into this person's background and their associates, and friends and family members, trying to find other things that would potentially be, counted as racist or sexist or bigoted or, what have you. And then that would be put together. And then people would start in a coordinated way targeting the school they went to and saying, hey, do you really want this person representing X university? We saw people be kicked off of teams. We've seen a couple of expulsions. We've seen, mostly universities saying, oh, they're looking into the issue. They've referred it to discipline. So a lot of these things are probably still out there in the air. And one of the, really tough things is because of the effect of these things and the way it affects people's reputations, and really just the idea that there's people who are out there that you don't know that are sort of dedicated to getting you and making your life worse. A lot of these folks, while they might come to us, they don't want to make a bigger issue out of it. They're looking for help from somewhere, but at the same time, the very fact of fighting back brings you to more notice from the same people that you're afraid of. And so that mobbing effect really is a very strong and powerful force. And, I think we'll be seeing probably some of that revived as school opens up, although maybe not in the same manner. But at the same time, we've also got a very highly contested and strong an election with a lot of strong feelings behind it. We've got the continuing COVID crisis. So, there are a lot of stresses, probably more on the college scene than we've seen since the late 1960s.
Yeah.
I always liked, people would say, oh, how can it get any worse? And I'd say, well, back in the late 60s, there was something like one of the years, I think it was 68 or 69, there were something like 40 bombings on college campuses. So I was telling people, well, it could get worse. Well, I think we're obviously we're not at 40 bombings level, but with the violence and that sort of thing that, we're seeing, thankfully, mostly off campus, we're probably closer to that now than we've ever been since I've started 17 years ago.
I want to talk about some of these cases because some of them are just truly extraordinary, even over the course of the past 10 years that I've been here at Fire. There's one at Fordham involving a Chinese-American immigrant, a student named Austin Tong, and he posted on Instagram in the wake of the George Floyd protests. He posted a photo of himself holding a gun in his backyard. It was also the 31st anniversary of the Tiananmen Square massacre, and that's why he was posting the photo. But he had another posted around the same time, again in the wake of the George Floyd protest, in which he criticized what he had seen as a nonchalant response to the homicide of retired St. Louis Police Chief David Dorn. And as we all know, one of the things that can land you in hot water on college campuses is supporting the police at a time when the overwhelming, kind of opinion seems to be that the police need reforming. And this student, Austin Tong, was saying, we should care about police officers who are murdered, but that was seen as a criticism of Black Lives Matter. And there was a strong response after seeing that and his poster of him holding a gun on the anniversary of Tiananmen Square, that there were calls for him to be punished at Fordham. And in response to these posts, Fordham found him responsible for violating its policies prohibiting threats and intimidation and or bias and or hate crimes. And there was one article in the student newspaper, the Fordham Observer, that I thought really was kind of emblematic of this cancel culture that so many people are talking about this summer. The article was titled, "How Do You Solve a Problem Like Austin Tong?" And the writer had a quote that said, "Tong's actions are counterintuitive to Fordham's reputation as a business, and as such, he should be metaphorically fired from his position as a member of the Fordham community." You could replace canceled with fired in that case. But it just goes to show how these communities are just trying to police thought and opinion and to try and make it conform with whatever the prevailing orthodoxy at the time might be. Now, Austin Tong is unique, as you were talking about, Robert, insofar as he's fighting back and he hasn't apologized. He came to Fire for help. He also hired an attorney. He's suing the school. He's appeared and done media interviews about it. But as you said, there are a lot of people who are afraid of what could happen to them in their careers, or their names getting dragged through the mud, or what might happen on social media. Sam, there was one case at the University of North Texas that you broke the news about in National Review. Can you talk a little bit about that one?
Yeah, so there was a music theorist who gave the plenary address. This person's name is Philip Ewell. He gave the plenary address at the meeting last year of the Society of Music Theory, or Society for Music Theory, and that address was about how essentially music theory could be seen through a white racial frame, and it particularly called out this very famous music theorist Heinrich Schenker for his racism and for sort of this placing this white racial frame on music theory. And there's actually a center at the University of North Texas in their music department, Center for Schenkerian Studies, devoted to the study of Heinrich Schenker and his music theory. And this center is headed by this professor, Timothy Jackson, who also runs the Journal of Schenkerian Studies, which is a publication of the Center for Schenkerian Studies. And if this is all sounding very obscure, it is. And most people, as I pointed out in my National Review article, had probably never heard of it before this controversy came to light. But in the Journal of Schenkerian Studies, the Journal of Schenkerian Studies solicited and then published a series of responses to Philip Ewell's plenary address. Some of those responses were favorable, some of them were critical, and Timothy Jackson himself published one that was critical, challenging the idea that Schenker was himself a racist and discussing the way that Schenker's views had evolved. Schenker was Jewish and lived in Germany in the years leading up to the Holocaust, and how the rise of Nazism may have changed his views on race at the time.
And I hate to interrupt, Sam, but this guy was, we're arguing over whether this guy was racist or not. This guy was born in 1868. So just to give you a perspective, this is not a person who is alive right now that we're debating. These folks are debating about a guy who died in 1935. But go ahead.
So anyway, after this issue came out, it received a very critical response. People, began denouncing it. And of course, predictably, not just announcing it, but calling for an investigation into the journal, saying, it must have been, it must not have gone through the appropriate peer review. Never mind the fact that this sort of, call for responses is a standard practice and is not sort of the sort of thing that would be typically put through peer review. These aren't studies. These are just fellow scholars' responses to the address. And so, of course, you have the predictable calls for not only investigation, but from a group of graduate students at UNT explicitly pretty much calling for Timothy Jackson to be fired. And of course, these controversies never end there. Universities never seem to have the courage to stand up and say, actually, this is protected speech and there's nothing here to investigate. Instead, they inevitably capitulate to the mob, and so predictably have launched an investigation. And Professor Jackson is currently being represented by a good friend of mine. So he has an attorney, and he is fighting back, but it's been very difficult for him. And I think, we are trying to sort of, Fire and other organizations are trying to create a culture in which people can speak out and fight back against these sort of cancellation efforts, and not feel perhaps so alone. But I think right now it really is, people, when they decide to fight back, they really feel largely very alone. It's very isolating, and very few people have the stomach for it, and that's part of the problem.
Well, one of the things that struck me about the University of North Texas, and I believe it's the music school of which Professor Timothy Jackson is a part of, that is launching the investigation. One of the things that stuck out to me about this statement announcing the investigation, and I don't have it in front of me, but if I'm remembering it correctly, they said something like, "We're launching this investigation to show our support for racial justice or a fight against it. It wasn't even, we're launching this investigation because we think someone might have done something wrong here. It was like they launched the investigation because they thought that that's something they needed to do in order to show solidarity with some sort of outside cause. Am I remembering that statement correctly, Sam?
I also don't have it in front of me, but I do believe I don't know whether the line about solidarity came from the university's investigation or from sort of the calls on the university to investigate. But either way, the idea, I mean, it all comes down to this sort of idea of appeasing the mob. I mean, I'll reference.
Oh, here it is. Here it is. From your op-ed in National Review, John Richmond announced that UNT is opening that investigation in the name of, quote, reaffirming our dedication to combating racism on campus and across all academic disciplines.
Right. I mean, this is all about appeasing the mob. I mean, I have a case right now that, if anything, reflects, this sort of appeasement mentality. It's this one. There was a professor who posted some tweets to his personal Twitter account that people became very upset about, and fire him started trending on Twitter, and people started protesting both at his home and in front of the office of the university president. And the university president pretty much explicitly said, in a disappointed way, the Constitution, we can't fire him for this. The Constitution protects his right to say these things, and that's the law. But then, just days later, announced really the opening of what can only be called a witch hunt into this professor, saying if anybody has experienced, bias or discrimination in his classroom, please come forward with accusations. So you have this professor.
That's so Soviet. It's like, I've shown you the man, now find me the crime.
Well, exactly. And so, this is a faculty member who teaches, he's a psych professor, and he teaches some very controversial courses on sexual behavior and cross-cultural psychology. So there was plenty of material. So this call for complaints was issued. Hundreds of people who had never come forward before. In fact, this professor has gone back through years and years of course reviews. None of these allegations were ever mentioned. This is someone who'd received for years outstanding teaching reviews. Suddenly, hundreds of complaints come forward, and the university is subjecting him to really what can only be called an inquisition. He had a 4-hour meeting last week in which they just asked him verbatim about hundreds of accusations made against him, making no effort whatsoever to weed out accusations that were exclusively related to his choice of teaching material, making no effort to consolidate duplicative allegations. So, there was 4 hours of this, and at which point he said, hey, I'm getting pretty tired here. Are we almost done? And we learned that we weren't even halfway done. So tomorrow he's got another 5-hour inquisition to ostensibly finish up this process. But it's just insane. And it's very difficult for me to imagine many people being able to withstand that kind of pressure. And when I think about, would he speak out again? Would anyone who knows what happened to him for speaking out speak out? The universities are really, and I think this goes back to that lack of accountability. They're brazen. They know they can get away with these things. They know very few people are going to challenge them. And they really act like sort of the kings of their own little fiefdoms.
Yeah.
I may have just horribly mixed metaphors there. I don't know.
I rise in defense of attorneys, which is never a popular thing to do. But one point I like to make, and which frankly these days can't be made often enough, is that one of the fundamental lessons of Anglo-American jurisprudence that we've learned over really 1,000 years of experience, these things aren't necessarily intuitive, but that when you have an investigation or when you're engaging in some sort of disciplinary process, whatever it is, the inquiry has to be about the actual person and the thing that is being investigated, and can't be about making some sort of societal statement. And, that's, frankly, it's the lesson. People don't like to think about it, but it's a lesson behind the book To Kill a Mockingbird, which is so powerful for so many of us going there or who have gone to law school, is the idea that, like, the very idea that the UNT music department would say that they're going to open this to show their commitment to racial justice, or, however it is they put it. The only reason to actually investigate a person, the only way that you can do it that's not prejudicial, is to actually open it because you think they did something wrong, like they individually did it. You can't hold somebody accountable for what somebody who is not them thinks or did. And when you get away from that, injustice happens immediately. And one thing I'll say about the legal system is very good about trying to filter that out. It's not always successful, but it makes really Herculean efforts to do so, in a way that university administrators just simply aren't trained to do and don't even think about. I don't think it occurred to the dean at UNT that there would be any problem with saying that, but that's literally the same argument for giving people show trials, like you mentioned, for making a societal statement by hanging people without benefit of trial because you don't like whatever it is that what they are supposed to have done says about your society. And so the fact that again, I guess accountability is maybe the theme here, but people don't even think about what it is they're instituting here and the sort of nightmares that it's taken us 1,000, literally, I'm not exaggerating, like Magna Carta to now, practically 1,000 years to realize that this isn't the right way to run a society.
There's another case out of Tulane University, and Robert, you talking about how people are being investigated to make a statement rather than things they actually did. At Tulane, there was an event that was supposed to happen, I believe, on August 6th, involving a author named Edward Ball, who wrote an anti-racist book called Life of a Klansman, A Family History of White Supremacy. And it was really his effort to come to grips with his ancestors' historical involvement with the Ku Klux Klan. And it's, of course, critical of that involvement. But that event was canceled after the student government claimed that the event was not only inappropriate, but violent towards the experience and work of Black people in the Tulane community in our country. And I'm quoting them there. And something else that stood out to me there is just how the criticism and the call for canceling the event didn't even really bear any resemblance to the truth. Like, so they wrote the dean and some of the leaders in the college at Tulane and said, instead of investing in speakers like Edward Ball, who are closely related to Klansmen, the School of Liberal Arts should prioritize uplifting Black voices, amplify the experience of Black, Indigenous people of color. Like, Edward Ball, I don't even know that he knows his ancestors who are Klansmen. And to say that this anti-racist man is closely related to Klansmen as if he holds those beliefs just doesn't even make any sense to me or compute to me. Like,
it's another example. I mean, that's an example of the idea of blood guilt, right? That the guilt for doing something actually transmits in your blood. Again, this is actually a very natural way for people to think. I think it throughout history, that's been an important concept, but it's one of the ones that I guess I and other people who are trained as lawyers in, 20th and 21st century America thought we'd gotten over the idea, that idea. And it's actually,
it's something they do in North Korea. Like, if one of your relatives tries to leave the country, then your family is punished as if their guilt is the same as yours.
That's right. And it all stems from, it's interesting because it all stems from the very same idea behind the problem that they're fighting, which is a big part of maybe the biggest part of the problem with racism, if you think about it, is that the injustice of racism comes in when you are applying a stereotype, you're applying a prejudice, that is, you have prejudged someone based not on what they did, but what you think about that person or people who are like that person, or maybe the ancestors of that person, etc. It's an unjust thing. It rubs people. I mean, people intuitively find that to be unjust when you are being judged for something that you personally did not do. It's a big part of the reason that racism is so morally wrong, and yet it's the same principle behind it is now being applied by universities and by other forces in society, and it's really very corrupting, and I think leads to a lot of the foment that we're seeing right now.
Well, it has me worried too. Our colleagues Greg Lukianoff and Adam Goldstein have an op-ed in the Wall Street Journal this morning, in which they say that free speech culture, regardless of what free speech law says, is important because the culture that we're raising our children and educating our students in right now, could erode those legal protections that we've laboriously worked to put in place over the past century, because these students, of course, and these young people are going to become judges and lawyers and policymakers and
just voting.
Yeah, and voters. And if that culture is gone, the law can't protect us. It's that learn in hand state. No paper out there can, protect your rights if I forget what it is, if the spirit of liberty dies in the hearts of men and women. So
if liberty lies in the hearts of men and women, when it dies there, no law, no constitution can save it.
There we go.
It's a great quote, and it's one that should be at the forefront of all of our minds right now, I think.
I want to quickly run through 3 other cases that I'm just going to kind of Gatling gun to kind of hammer home at how astounding this summer has been as far as our work goes. And then, Robert, I want to kind of close with what I think is kind of one of the most tragic cases that we've had this summer. And I know it is personal to you, but these 3 other cases, we had 2 at UCLA. One involving a professor, an Air Force veteran, who was referred for investigation after he simply read Martin Luther King Jr.'s letter from a Birmingham jail. And he was referred for investigation there because that letter, of course, uses racial slurs in Martin Luther King's relaying kind of the treatment that Black people in the South were experiencing. But his department chair also faulted him for showing portions of a documentary that included graphic images and descriptions of lynching, as well as this sort of narration that, as the chair put it, quoted the N-word in explaining the history of lynching. So this professor wasn't even using the words as a pejorative. He was just quoting history, essentially, and one of the most famous letters from the civil rights movement, and he was referred to investigation for that. We also had a professor at UCLA who was suspended, this is Professor Gordon Klein, for declining to alter exam schedules and grading practices for Black students in the midst of the George Floyd protests. And there was a talk about coordinated efforts to cancel someone. There was a change.org petition that garnered 20,000 signatures for UCLA to fire him. And then there's also another case, not really a case, but just kind of indicative of the times we live in at Syracuse, where a student, Adriana San Marco, was fired from her job as a columnist at the student newspaper, the Daily Orange, when she dismissed the notion of institutional racism in an opinion piece for a separate conservative website. This wasn't even an opinion piece for the student newspaper. And the editor there kind of justified it by saying that these opinions are out of bounds. So I guess there are some opinions that are out of bounds when you're writing for the student newspaper. But that kind of struck me because I was a student newspaper at the Indiana Daily Student when I was a student there. And they're just kind of purging people who don't conform to the orthodox on campus now. But there was one professor at the University of North Carolina, Wilmington, who for a decade now has been fighting against conformity of orthodoxy and fighting to defend his right to academic freedom and to his opinion. And unfortunately, we lost Professor Mike Adams last month to suicide. And Robert, you had written about all that Mike Adams had done for the cause of free speech, but also due process over the past decade. So I kind of want to close by sharing his story, if you would.
Yeah, Mike Adams was someone actually, he ended up having to fight for more than a decade. Toward the beginning of the 2000s, he was a professor at the University of North Carolina, Wilmington, a criminology professor. And he started out his professorial career as a liberal, political liberal, and an atheist, and had a conversion experience. He converted to Christianity and also converted to being a conservative, and was someone who, in a very sort of American style, was very brash and loud about his opinions. He was a columnist, I think, for Town Hall and other outlets over the years, and also, someone who engaged on social media, would write for the newspaper and that sort of thing. And he was, ever since I began at Fire, Mike was always sort of in a little bit of peril. He was on the tenure track, and the University of North Carolina, Wilmington, denied him tenure, citing his outside writings. Now, he engaged in a lawsuit and actually, at one point, fires former president, and then he had left and joined the army during the Iraq War, and came back and was Mike's attorney when he was suing to get tenure and establish.
That was David French, of course. He's
That's
been
right.
on
Sorry,
the
I should have
podcast
said, yeah,
before.
David French. Yeah, exactly.
Works for the Dispatch now. Yeah.
Yeah, I left that out. And so Mike had to sue UNC Wilmington to establish that was an illegitimate reason to deny him tenure, and he succeeded. It's actually Adams versus UNC Wilmington is actually one of probably the leading case on an issue, the issue called the Garcetti issue, but basically it's the issue of whether or not or to what extent public universities can control the speech of professors like they can other public employees. So he fought that out. And he had fought, various other sort of battles with the UNCW. They were never really reconciled to having him there, but they couldn't really get rid of him because he was widely cited and very successful and good as a professor.
And he won the court case.
Yeah, he won the court case, which took something like 4 years, right? So he had become, kind of a fixture there. But earlier this year, in the middle of the COVID stuff, he sent out a tweet that he was complaining about North Carolina's restrictions on COVID. And he basically said in the tweet that he was having some beers with friends and felt like a free man. And he said, "Massa Koopa, let my people go." And this led to, sort of another eruption of outrage. And in this case, they successfully pressured UNCW, which frankly probably didn't take a lot of pressure to get them to pressure Mike into taking early retirement. So they were due to pay him $500,000 plus.
And he was like 55 years old, right?
Yeah, he was 55. So, I mean, it was a big chunk of money, but, not necessarily like, set for life, not set for life kind of money.
Yeah. It's not going to get you to Social Security.
No, I mean, not, depends on how you live. Right. So, but a big chunk of money, but not, golden parachute level stuff. And unfortunately, I had actually emailed Mike and others at Fire and others I've talked to since had emailed. And, I remember saying, "Hey, Mike, I saw that you're negotiating retirement, sorry to see it. I hope it's, what you wanted or whatever." And he's like, "Well, we should talk about it. Let's give me a call sometime." And
Yeah, that's the same thing that happened to me. I reached out to him and he said, let's talk on the phone, which, was unexpected because we'd never communicated that way before. But, we did have a long talk.
And I had talked to, and you talked to Mike, and I had talked to Mike and was, friends with him, not like I was hanging out at his house or anything all the time, but we were friends. And, found out that, he was dead of a gunshot wound. People were, sending me this. They'd seen it on Twitter. And about a week or two later, I forget exactly when it was, they ruled it a suicide, which is, what I had suspected. But it really brought home to me and I wrote about this on Fire's website, and I'd invite folks to read it. But it really brought home to me the hidden, but maybe not so hidden costs of what it means to actually go after someone's livelihood and their reputation in such an unrelenting way. I mean, Mike had basically been taking 2 decades of punishment, and he seemed like one of those people who could happily take it, but you never really know, right? And so one of the points I wanted to make, when writing about him, was that you need to count the cost of what you're doing when you're engaging and when you're joining a cancel culture mob, when you're trying to get somebody ruined for what they said, not what they did, but what they said. And you need to realize that you never know what the result of that's going to be, but the predictable result of going after people's livelihoods, their careers, their reputations like that, is that some of them are going to sink into depression and some are going to take their own lives. And when you join that mob to do that, you need to be aware that you are taking on the moral responsibility of being a part of that. And I don't think people really give enough thought to the actual downstream effects. And I think social media is it's kind of a bad system for making people think through those, because you can just basically throw your virtual Molotov cocktail at Mike's, reputation, and then you never have to think about him again. But the aggregate example or the aggregate effect of that on someone, even if all of those are protected, and I think that most protected speech, and I think that the vast majority of the vitriol that Mike almost certainly was protected speech. Just because it's protected by the Constitution doesn't make it morally right. And I don't think people think about the ramifications of that. And in this case, I think it's pretty fair to say that Mike was canceled to death. I lost a friend, and I think I'm sad. Obviously, it was a hard thing to write, but I'm also sad for the folks who participated in that. And I try to, look, I'm a Christian, right? I recognize I'm a sinner like everyone else. And I don't think you have to be a Christian or religious of any kind to realize that, we all have our own problems, and we all do things that are wrong, and we should have some recognition of that. But the idea of having being part of a culture where you can ruin people and not even be aware of it, and people can end up dead at the end of it, because the consequences of what you've done are so divorced from the actual action, I think is morally a really risky and sort of terrifying place to be. And the only solution to this is a cultural solution. People need to literally, judge people. You can judge people by what they say, et cetera. But we need to come as a society to some kind of recognition that, these things have real consequences for the people we're dealing with, and that they are humans like we are, and that they deserve the respect that we would accord a neighbor or friend.
Yeah.
I think it's important to remember that.
Well, and I think there's been
Even
so
if
much
you disagree
debate.
with them, nobody's perfect,
Well,
but
I think
none of us are.
Yeah, there's been so much debate about what actually is a canceling, what is cancel culture, what qualifies as a canceling. I think for many of us, we just kind of know it in our gut when we see it. It's very clear when someone's engaging in debate and criticism to try and win an argument, and when someone's trying to shut someone down or get them to lose their job or ensure that they can never be a part of the public discourse again. I think we can all kind of tell when that line is crossed, even if it's otherwise kind of hard to define.
Nick Christakis actually has a sort of working definition of cancel culture that I think is pretty useful. He called it, and this was something he published on Twitter. He said, 1, forming a mob to. So it's by cancel culture, I mean 1, forming a mob, to 2, seek to get someone fired or disproportionately punished, for 3, statements within the Overton window.
Yeah, and Robert actually in his Mike Adams piece, which I encourage everyone to read, and Robert's great kind of synopsis of it, I hope has kind of what everyone's appetite to read the full piece. Robert, you also have kind of 3 examples of what qualifies.
Yeah, I came up and Nick, the Professor Christakis, I should say, and John Rauch both informed sort of my thinking of what's as opposed to the culture, what's an example of a cancellation attempt. And the things I came and I was thinking about this because of what happened with Mike, and the 3 I came up with, and this is a working thing. This is not definitive, necessarily, but is the aim of the alleged canceller to silence or deplatform the target, as opposed to persuade him or others that he's wrong? Is the alleged canceller demanding the target be fired or otherwise punished for his expression rather than for his actions? And 3rd, is the alleged canceller trying to get others to join in making the demands or participating in such a campaign? And I think if it's yes to all 3, then I would classify that as a cancellation attempt. So I tried to get one that doesn't, involve the judgments of where the Overton window stands. The Overton window, just for folks who don't know, is the idea that there's a certain sort of wide mainstream of opinion, and things on either side of that are kind of unacceptable. But I would say that even if you're trying to cancel, David Duke, it doesn't make it not canceling. It might reduce your it might justify what you're doing, or you might decide it's worth it, but it doesn't mean you're not trying to cancel him. So I think we're going to grope towards a definition that works. I think there is one. It is tough though, and I think right now you're right, Nico. Most people can sort of tell whether or not this is a sincere disagreement kind of thing versus a cultural putting the arm on somebody culturally.
Yeah, and Jonathan Rausch, who of course has been on
It's
this
a little like
podcast.
Justice Potter Stewart's obscenity definition. I know it when I see it.
I actually said that. Greg and I were talking yesterday. I said the same thing. It had elements of that, but Robert, you mentioned religion. I'm not a religious person. I'm probably agnostic, if not atheist. But yesterday, someone sent around to the office a short piece by Nick Cave, who I guess is a musician, a musical artist. I'm not familiar with him, although I understand now that he is popular. And many years ago, he lost a son in a tragic, I believe it was, car accident. And since then, he's been having this blog called The Red Hand Files, in which he responds to readers, questions often about, tragedy in their life. But the one he posted yesterday or recently was asking him, what do you think of cancel culture?
Mm-hmm.
And he had this great line in there. He begins by talking about mercy in the first 3 paragraphs, and he talks about how tolerance allows the spirit of inquiry, the confidence to roam freely, to make mistakes, to self-correct, to be bold, to dare about doubt, and in the process, to chance upon new and more advanced ideas. But he said as well, addressing the correspondent Francis, you've asked about cancel culture. He says, as far as I can see, cancel culture is mercy's antithesis. Political correctness has grown to become the unhappiest religion in the world. Its once honorable attempt to reimagine our society in a more equitable way now embodies all the worst aspects that religion has to offer, and none of the beauty. Moral certainty and self-righteousness shorn even of the capacity for redemption, it has become quite literally bad religion run amok. Now, Robert, you might take umbrage with some of what he has to say about worst aspects of religion, but I thought that was very insightful. His idea about how cancel culture is mercy's antithesis, and within a cancel culture there is no opportunity for redemption. And I don't know, regardless of whether you're religious or not, whether any of us wants to live in a society without redemption.
No, I think that's a very, very good point and a very wise observation. It is a very unforgiving place, and it's important for when you hold these things as articles of faith, they start to take on the aspects of a religion, whether or not you see it that way. And I don't disagree. I don't think it's yeah.
Well, we've talked about a lot during this podcast, and putting together show notes for this show will take me a very long time. So we're going to get the episode up here very soon. I don't know that in the description I'll have show notes right now, but a lot of the stuff that we've discussed has been covered on Fire's website, or Google can be your source there. I'll try and get show notes in the days to come. But I think we're going to end it there. Sam and Robert, I really appreciate you two taking the time with me, especially on such a busy day.
Yeah, thank you.
Thank you.
This podcast is hosted, produced, and recorded by me, Nico Perino, and edited by Aaron Reese. You can learn more about So to Speak by following us on Twitter at twitter.com/freespeechtalk, liking us on Facebook at facebook.com/So to Speak podcast, and emailing us feedback. I try and respond to all the email correspondence I get, and email us at sotospeak@thefire.org. Again, if you enjoyed this episode, please consider leaving us a review on Apple Podcasts or Google Play. That is the single best way to help us attract new listeners to the show. And until next time, thanks again for listening.